Maybe what I will do is, as people are rolling in, I'm going to get this going. I want to thank you for being here for this lunch hour. It's definitely not Melissa's lunch hour, but she's all the way in Ontario. My name is Sandra Azakar, and I'm the Executive Director of Friends of Medicare. And behind the scenes, I have Alyssa Pretty, who is our Communications Director and the one who always makes this type of webinar go very smoothly. So I would like to start out today by respectfully acknowledging that we're joining you from Treaty 6 territory, a traditional gathering place for diverse Indigenous people, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, Anishinaabe, Inuit, and many others whose history, languages, and cultures continue to influence our vibrant community. Just a little bit of housekeeping before we start. I just want to point you to the icons at the bottom there. There is an icon that says Q&A. That's where we hope that you'll be able to put your questions. Don't put them in the chat, because sometimes the chat goes off in other directions and I just don't have the ability to kind of sift through that. So if you can please kindly put your questions there. What we will do is we'll have Melissa speak about our subject today, and then open it up for as many questions as we can get within this hour. So again, thank you for taking the time to join us on a very timely conversation. And I will let you know why it is so timely. And the majority of you are aware that today, after 1:30, after question period, the legislature will be debating Bill 70 for the third reading. I think they're still in committee of the whole, and then of course it goes into third reading, and then the bill doesn't automatically, but there's debate around it, and then given the fact that this government has a majority, I don't believe that unless we have somewhat of a miracle, that this bill will definitely be passed. Bill 70 is the COVID-19 Related Measures Act, a legislation that was introduced on April 22nd, 2021, and it intends to ensure legal protection for health services facilities, including continuing care operators, some of which are currently facing lawsuits over illness or death due to exposure to COVID-19. This legislation is retroactive to March 1st, 2020, even prior to when Alberta enacted emergency public health measures. Of particular concern is that the sponsor of this government bill is MLA from Calgary Fish Creek, Richard Godfrey, who was also tasked with chairing the facility-based continuing care review that made 42 recommendations that, simply put, and without going into more detail, simply serve to change who pays for care. The recommendations that we will see coming out of that review that will ultimately shape and inform the continuing care legislation that will be tabled in the fall of this year. We will see a downloading of cost and care responsibilities to residents and families. In January, Alberta's lobbies registry shows that the government was lobbied by representatives of the for-profit private continuing care industry. And what they were doing when they were lobbying is they were simply seeking legal protections against the potential impact of COVID-19 related lawsuits from residents. It begets a question then as to who is the government trying to protect with this bill? Where is the legislation to protect the residents from this pandemic experience? And that's a question that this whole process has made us ask. The sad reality for us is, with this bill, is that it will not allow families of those Albertans who died during COVID the ability to seek answers and hold care homes responsible for negligence of their loved ones. 2020 was a harrowing year for seniors, with over 1,258 out of the 2,274 COVID-related deaths were of seniors residing in long-term care and supportive living sites. It was our hope that our government would have finally recognized that the way in which we care for seniors is not what we should expect. The rules and regulations in place were not up to the level of crisis that was increased by the coronavirus pandemic. Rules and regulations that were badly enforced, if they were enforced at all, and which were woefully inadequate to protect residents. Throughout the debate that has been held so far, what we have heard is talking points such as Ontario, Saskatchewan, BC passed similar bills, and so you shouldn't worry about it. You know, if we don't have this type of protection in place, the insurance rates will go up sky high, and then to the point where these operators are not going to be able to operate. All those kinds of things is what we're hearing from this government during this debate. Last year in Ontario, the Ford government passed a similar bill called Bill 218, supporting Ontario's Recovery Municipal Election Act 2020. I don't know why they added that part to it, but this is why we thought it would be a great interest to bring Melissa Miller to speak to us about this bill and how it compares to Bill 70 and what they have seen so far coming out as a result of the passing of that Bill 218. We're very fortunate to have Melissa with us today. Melissa is an advocate for the most vulnerable members of our population, the elderly. Being certified in elder law, she concentrates on nursing home negligence, long-term care case, and elder abuse. Her practice is also committed to all areas of personal injury litigation, including product liability, hospital negligence, car accidents, slip and falls, and long-term disability claims. Melissa is a trusted advisor who supports and guides clients through the legal issues that need to be resolved as they fight to recover. Melissa is an experienced trial advocate and is prepared to take her cases all the way. Melissa is a member of many professional associations and frequently authors articles for these associations and other organizations, including updates on law, catastrophic impairment, and important issues that affect the rights of injured victims. Melissa was elected to the board of directors of the Ontario Trial Lawyers Association in 2017, and she's also a founding member of Canadians for Long-Term Care. So we're very fortunate to have Melissa with us today. So I'm just going to hand it over to Melissa.
Well, thank you so much for that introduction, Sandra. It's really great to be here, although I really wish that you guys didn't need to be hearing from me today, because this legislation is essentially a license to kill, as far as I'm concerned. As far as many are concerned, because what we're seeing, what this really boils down to at the end of the day is, in order for families to be successful in proving or to be successful in court and to prove their case, they have to now meet a standard of gross negligence instead of regular negligence. What does that mean? It means homes that are simply negligent get away with it. Now, that's sort of my broad brushstroke summary of what the hell that is this legislation, but and I'll get into it in a little bit more detail. What we heard in Ontario, what we heard in BC, what you guys are hearing in Alberta is the same thing, exactly what Sandra said. We need this legislation to protect what Doug Ford called the mom and pop shops. I watched the question period, the debate over Bill 218 in Ontario, and our Attorney General, I don't know how many times, talked about supermarket store clerks and hockey coaches repeatedly. Well, no one is suing supermarket clerks or hockey coaches. In fact, no one has named a single PSW, nurse, or doctor in any lawsuit in Canada, as far as I'm aware, in relation to COVID-19. Any of the lawsuits are targeted to the owners and operators of long-term care homes, continuing care homes, organizations that are meant to care for the most vulnerable members of our population. I did see that there's one class action against a restaurant in Alberta. That's, as far as I could tell, the only lawsuit against an entity that wasn't a continuing care home, but it sounded like there was a pretty bad outbreak there. So I'll sort of park my comments with respect to that, because It's a bit of an anomaly in terms of how the lawsuits have been commenced. Generally speaking, the lawsuits are, as I said, against the owners and operators of long-term care homes, continuing care homes, retirement homes. And the allegations are pretty much the same, that there were completely inadequate IPAC measures, infection prevention and control measures in place. There's a lot of difficulty with this legislation as it stands. And I'll get into some of those difficulties. It sounds like it's going to pass. So while I'll talk about some of those difficulties, I think it's also important to talk about how we deal with this legislation, because it's kind of here to stay. But it's something that I think is really important to understand when elections are coming up. I can tell you that this is going to be an election issue in Ontario, which is a year from now, a little under a year from now at this point. And it's because we've heard our leaders talk about accountability. We've heard our leaders talk about the fact that the bad actors or the bad apples will be held accountable. This legislation throws a very wicked wrench in that kind of accountability. The first reason for that is, as I said, in order to be successful in a case against an organization, and including a continuing care home, you have to prove gross negligence, not just regular negligence. And that's because of the way the legislation is written. The legislation is almost identical. The Alberta legislation is almost identical to, or actually word for word, other than the words continuing care in place of long-term care home, that no cause of action or no lawsuit can be brought against, we'll say, a continuing care home if the owners or operators, the actors, the organization has made a good faith effort to follow public health guidelines, municipal, provincial, and federal law with respect to COVID, okay? So if someone got sick from or died from COVID, unless they were grossly negligent. Good faith effort is designed as an honest effort, whether that effort was reasonable or not. I laugh because when I read that, the BC legislation is worded slightly differently. When I read that, it was as if Doug Ford had written the legislation himself. It is the most ambiguous legal definition you could possibly have in a piece of legislation. It's entirely subjective. What is an honest effort? And whether that effort was reasonable or not. Civil law in Canada is based on the concept of reasonableness. You are negligent where you have not acted reasonably. So what this legislation does is say you could have acted reasonably or unreasonably. If you've acted really unreasonably, grossly negligent, then you could be held accountable. But you could have acted reasonably or unreasonably and you will be immune. That flies in the face of our entire common law, civil law standards. In fact, I've done some research on this. I've spoken about this a number of times. I've spoken with defense counsel who have started defending some of our lawsuits in Ontario. No one knows what it means. How is a judge supposed to determine what an honest effort is? It's a complete subjective test, and our laws are based on objective tests. What a reasonable person would do in the circumstances. And no one is suggesting that these homes should have acted perfectly. No one is expected to act perfectly all the time. We are all expected to act reasonably in the circumstances. Well, the circumstances are that we were in an unprecedented pandemic. Certainly a court would consider those circumstances when determining reasonableness without the need for this legislation. It's already difficult enough to meet that standard without this legislation. So imposing this legislation adds that extra added level of burden on the families looking for accountability for these quote unquote bad apples. And why that's so problematic is no one knows what gross negligence means either. Outside of some car accident cases in the 1970s and some contract cases that go back even a little bit further, in Ontario at least, the only time courts consider the definition of gross negligence is in municipal sidewalk cases. So if you slip and fall on an icy sidewalk in Ontario, you have to prove that the municipality was grossly negligent, not just negligent, okay? Gross negligence really just means really bad negligence. But we don't have a body of precedent to rely on, to compare, because proving negligence is already challenging enough for a plaintiff, especially families of vulnerable residents of a continuing care home or long-term care home that are relying on the records of the home in order to prove their case. They're already disadvantaged. And so it adds insult to injury because, I mean, at least in Ontario, we have licenses getting approved for more beds in homes that had horrifying outbreaks with the military coming in, plus they're being given immunity for lawsuits. It's unconscionable that this is the result. The other way this legislation is extremely problematic. So we have this idea, we have extremely ambiguous language in the definition of good faith effort and gross negligence. We don't know how that's going to be determined, which means the lawsuits are just going to get longer and more expensive. No plaintiff lawyer, no family who's got an existing lawsuit or a potential lawsuit is going to give that up because of this legislation. What does that mean? It means that the insurance company that was insuring the continuing care home is going to have to respond to these lawsuits anyways. And that insurance company that pays for the defense costs, now instead of us being able to resolve these cases reasonably and on a normal litigation timeline, with the already complex challenges of litigation in the middle of COVID, and as I said, the circumstances being a pandemic, we have legal uncertainty. And legal uncertainty usually means testing that in court. It means you're going to have to litigate what a good faith effort means. You're going to have to litigate what gross negligence means in the circumstances. It means a higher burden for the families, longer investigations, and it means the insurance companies are going to be paying their defense lawyers more legal fees, not less. That's what it means. So I think it's a cop-out for our governments to rely on the fact that this is an insurance issue. And if it's an insurance issue going forward, i.e. these continuing care homes are going to have difficulty getting insurance going forward, well, with all due respect, that's an issue that should be managed by the government with these continuing care homes and Alberta Health Services, and not to be borne on the backs of families who've needlessly lost loved ones in a continuing care home as a result of improper IPAC measures across the board, because that's what we've seen. So it's problematic from a legal definition standpoint. It's problematic from an insurance standpoint. And then the fact that it's retroactive, it means that even if the lawsuit was already started, if you're claiming negligence after March 1st, you've got to prove gross negligence. And if the pleadings, so if the lawsuit doesn't contain the language of this legislation, if you're not pleading this higher standard of gross negligence, your case is deemed to be dismissed. And this is what's been happening in Ontario. These defense lawyers that wrote letters right away. Given Bill 218, your case is dismissed. Well, what did I do? I issued a new claim and I pled gross negligence. Again, it didn't get rid of the lawsuit. The class actions in Ontario, on the other hand, there's been some challenges with amending pleadings in that respect, because as is par for the course for the Ford government in Ontario, there was also legislation passed that made changes to our Class Proceedings Act, which makes it more difficult for plaintiffs to bring class actions, because the test to get a case certified is more difficult. You have to have more common factors in order for a class action to be appropriate. So many of those who've brought class actions in Ontario are hesitant to commence new actions for COVID because of the change to the Class Proceedings Act. I haven't been following what's been going on with Alberta's Class Proceeding Acts, but Ford and Kenny are in lockstep with each other seemingly on these issues, which is terrifying. And I wouldn't put it past this majority administration to make similar changes as well. So in any event, it's created some legal and logistical challenges, and that presents a fundamental problem in terms of the administration of our legal system. We all don't know all of the laws, but not knowing the law is not an excuse for abiding by the law. We all know that, right? You get pulled over by a police officer with a speeding ticket. It doesn't matter if you knew what the speed limit was or not. If you were driving beyond the speed limit, you're breaking the law, you get a ticket. Similarly, these continuing care homes, whether they knew or didn't know, which they should have known, they knew that if they acted negligently, they could be held responsible. Up and until today, when I guess if the law gets passed, those operators and owners of the homes knew or ought to have known that if they fell below the standard of care and did not act reasonably in the circumstances, they could be held liable in our civil justice system. And this law gives a free pass for all of those who broke the law before today. A free pass. So, and it's giving license going forward to break what otherwise would have been the law unless they're grossly negligent. We are almost over the third wave here in Ontario. Epidemiologists are talking about a fourth wave because of the Delta variant, okay? So the Bill 218 was passed at the end of November, which means all of the homes that had outbreaks in Ontario during the third wave may have done so because they knew they couldn't get sued. I don't know. We don't know. That's problematic. It is a huge problem if any single one of the members of the administrations of any of those homes became a little bit more lax because of Bill 218. It is extremely problematic if any of the continuing care homes become a little bit more lax in how they're managing COVID and protecting residents from today onwards because of Bill 218, Bill 70 in Alberta. So and that really erodes the foundation of our legal system. To have retroactive laws like that just provides sweeping immunity, because it takes away from what we can all rely on as true and what we know or ought to know we are to abide by in the circumstances. So I think that, there's many layers of problems with this legislation, and it's just so, it's so rooted in the foundations of our legal system, or it flies in the face of the foundations of our legal system. So I think that going forward, Bill 70 is something that, if passed, must be at the forefront of any election discussion against this conservative administration going forward, because it's that problematic. And I think that, and the one major difference between Alberta, the Bill 218 and Bill 70, is that we have, our health care systems are slightly different. AHS is like permeates every aspect of healthcare and long-term care and continuing care in Alberta. We have separate pockets, separate silos in Ontario. Nevertheless, because Sandra and I spoke about this before, and the concern from AHS is that this Bill 70 is, without it, frontline workers could be sued or brought through the ringer when they've already been brought through the ringer. Carve out, fine, pass immunity legislation, carve out continuing care homes, carve out those institutions that we know have been the bad actors. The unwillingness of our governments to do that shows us who they are really protecting. And it's, for the most part, as we know, the private home operators. We know that there's connections between government and these home operators. It's, it's not even news anymore. It's just very well known. So I think that this legislation is the epitome of all of the things that we've been talking about throughout the past 14 months in long-term care and across Canada. The issues that we're seeing are being exposed by COVID. One of the biggest ones, the relationship between these companies that operate these homes and our governments, and the lengths our governments are willing to go to protect them rather than our most vulnerable. So I think that's primarily in terms of action steps, because I never like to only be the bearer of bad news. I like to be able to empower people. Even if this bill gets passed, it's incredibly important to maintain a voice throughout. I don't know when Alberta's next provincial election is, but I think it's imperative that we keep these issues at the forefront in the media with our politicians, so that they know that, I can tell you in the meetings that I'm going to be having with Ontario politicians, my expectation is a repeal of Bill 218. I want whatever new administration, I hope the new administration comes in, the expectation is a repeal. That is what we are advocating for. That's the standard that we expect from any new administration coming in. It's a big one, but that is, I think, what the ask needs to be when something like this has already been passed and it's already happened, because it's that problematic at a societal level, at the level of long-term care, and at the heart of our legal institutions and the administration of justice. I've been speaking now for a while, and maybe I think we can take some questions. Sandra, I haven't been monitoring the question and answer box, but.
For sure. Thank you so much, Melissa. I think if we weren't angry before, we're even more angry. I think you were able to clearly articulate the issue behind this bill, and it kind of clarifies some of the conversations that we've been hearing during debate in the last couple of days. And it's interesting to note that our Minister of Health is actually a lawyer. So when you're talking about how this bill flies in the face of the foundation of our legal system, you would expect that somebody with that kind of background would know better. But here we are.
They do know better.
Which is why he didn't introduce the bill, I'm thinking, which is why he gave it to somebody else, right? I'm just, while people are writing questions, we have a few in our question and answer, but one of the ones that really gets me is that understand or can't wrap my head around is this retroactivity. So how does a government, how is it even legal for a government to draw legislation that will allow the law to be changed going backwards? Because that could be for absolutely anything that a government doesn't want to see in place. And how does that leave the legal rights of the citizens at the total mercy almost of a government's will in terms of changing whatever law they don't like and imposing a retroactive one? Is that even a legal practice?
So, well, I mean, that's a loaded question because we've seen the Ford government and Ontario doing a lot of things that would be considered violations of our Charter of Rights and Freedoms, including most recently invoking the notwithstanding clause on a piece of legislation that was ruled to be unconstitutional by a court last week. And for those who don't know, the notwithstanding clause is in the Charter, and it basically says, notwithstanding any of these rights, a government can override for a certain period of time. And so what our government did here in Ontario is call an emergency legislative meeting over the weekend to pass legislation that has already been deemed unconstitutional. And that legislation is targeted at organizations that would run ads during the election campaign season, like unions of frontline workers that would want to oust the current sitting government because of its mishandling of the pandemic. So it's legislation that's going to silence interested parties, so to speak. So it happens. And the problem is when a sitting government does something like this, when a sitting government passes something that's retroactive, that's potentially a violation of Section 7 of our Charter, right? So Section 7 of our Charter is the security of the person. And it's arguable. There's been some legal discussion, with some of my colleagues about whether Bill 70, Bill 218, the retroactivity of it could be perceived as a violation of Section 7 of our Charter freedoms. But that's something that has to be tested in court. Because what happens is, you take the context of one of these lawsuits, okay? And the defense, so the insurance company representing the home, says, well, hold on a second. You can't be successful in this lawsuit. I'm going to bring a motion to dismiss because you can't meet the level of gross negligence. And they made a good faith effort. To which my response to that motion is, yeah, but the legislation that you're relying upon is a violation of Section 7 of the Charter of Rights and Freedoms. And you could have years of litigation on that issue. By that time, we've got a new government. This is the abuse of power that we're seeing with some of these states of emergencies with majority governments. It's terrifying because the legal recourse is a slow, methodical animal. And what we're seeing is swift, irrational action. And that's why the best course of action is ousting the current administration and electing in a new government that would repeal this potentially unlawful piece of legislation. It's a tough question. It's a tough place for us to be in. It really is. It's really problematic.
Yeah, that kind of plays into the question that we had around the issue of whether or not this was a violation of Constitution or Charter rights and freedoms. But going further from that question, asking if our charter rights were being violated here, it's also about, we've been having lots of conversations around this bill, and it's about ageism and discrimination in terms of, leaving the most vulnerable in a position where they can't access their legal rights. Mm-hmm. Is that something that could be considered under this charter right?
Yeah, I mean, that's another element of it too. There's a few different ways that, we could go about it. But again, bringing a charter challenge is extremely expensive, and it's something that would take years, because anything involving the charter has to go through, you know, the court system that would end up at the Supreme Court level, right? I mean, this is not a simple process, and all the while, who's paying for it? The families who've already suffered the loss to begin with. This is the problem.
Yeah.
It's injustice on top of injustice. It's exponential injustice. That's the problem with this one of the problems with this legislation. Yeah, there's possibilities are there, but when we're looking at what we're trying to achieve here by way of accountability, that's missing in the equation.
Yes, definitely. Okay, we have another question, and it's a good question in terms of are there not standards of care or best practice that for-profit long-term care homes have to abide by in order to be accredited? Where is the responsibility and accountability for the for-profit care homes?
So this is the sad part, is that there are lots of standards and regulations in place that these homes are obligated to meet. They don't meet them. In Ontario, for example, our regulations are like in such detail. I know the same is true for Alberta and BC and many of the provinces. These regulations for long-term care homes, continuing care homes, go into excruciating detail about what the owner and operator of a home is obligated to do to care for the most vulnerable residents in that home, and it is their home. We're seeing, and because there's differences across the provinces, there's differences in enforcement across the provinces. Some provinces have, like Alberta has a separate investigating body. Ontario, it's our Ministry of Health that goes in and does these inspections. I shouldn't say investigations, inspections. And the outcomes vary from province to province, which is why this is actually how Sandra and I came to meet, is, you know, in conjunction with the provincial and Canadian health coalitions and my group, Canadians for Long-Term Care, we've been advocating for national standards for long-term care, legislated national standards for long-term care. Essentially what we're asking for is for our federal government to step up where our provinces have been failing and say, if you want federal funding, if you want federal tax dollars to fund your homes, which how could you possibly turn down? You need to meet these set of standards, just like you do to get the health transfer under the Canada Health Act. Same thing. You want money for healthcare? Meet these standards. It's really not rocket science. What we're seeing instead right now is this think tank that's responsible for coming up with this new accreditation process. Where no one's really sure, quite sure what that is, but it's not something that's been instituted by our federal government. We have accreditation. There's already accreditation in place. Many of the for-profit homes that have been the subject of these lawsuits are accredited because you pay for the accreditation. There isn't any teeth behind it. We don't see any teeth in the enforcement of the standards that do exist. That's why these lawsuits are so important, because we're kind of the last stop. It's the last opportunity for accountability and justice where it's failed at the legislative, government, and regulatory level. And that's being taken away. These homes are being told, you just have to do an okay job. Not even that. You could be negligent. Run your home negligently in COVID. Please. Please do that. That's what they're saying.
Well, that's grim kind of thought. Yeah. And just to add that too, just accreditation is voluntary and it's a business. Yeah. It has become a business in the last little bit. It's a great thing to say that you're an accredited facility. You pay for that, right? Because it's a business. And you know, and basically there is no public accountability with accreditation, the business of accreditation. Whereas if we had, as Melissa said, a legislation, then that would be it would be a publicly accountable legislation, and that's a huge difference, which is what we have been talking about for a very long time now. We have another question. Could a new government retroactively repeal Bill 70 and 218 to reduce the standards to normal negligence?
Yeah, so when you repeal a piece of legislation, it means it no longer applies. It's like it takes it away. So yes, that would be the effect of that. And again, it can be challenging. There could be constitutional challenges to that too. But if the first law was unconstitutional in the first place, you know, you're sitting on some more solid ground. So yes, that's the idea, is that it would do that.
Okay, perfect. And another question here is, your organization, Canadians for Long-Term Care Standards, is at the forefront, but is there any wide-scale association, provincial and/or Canadian, that brings multiple lawyer associations together to fight against what you have identified are likely unlawful legislations, i.e. in general?
Yeah, so I belong to the elder law section of the Ontario Bar Association, and I was part of a task force, a COVID task force, where we got absolutely nothing done because the health law section that represents long-term care homes essentially kiboshed a lot of the efforts that we were trying to make. So in conjunction with a few of the lawyers from that section, we're starting a Lawyers for Long-Term Care group of our own that's really going to provide that, I guess, legal discord behind what other groups are already doing. And my group, we've been working very closely with Sandra and the other health coalitions across Canada so that we can have a joint effort. And that includes working with a lot of the unions. You know, we held a lot of town halls and heard from nurses and PSWs and frontline workers who also want national standards, who also want accountability, because they want safer working conditions and equitable pay. So this is the only, you know, I'm preaching to the choir here, but you know, we're the only ones gaining from legislation like this are the ones that are profiting from it in the first place. And that's obvious.
Definitely. I think, oh, there's another question here. Has there ever been in our country's history any successful lawsuits filed against a long-term care operator where damages have been paid or settled out of court? Any precedent-setting cases out there?
Yeah, absolutely, but not to do with COVID. So my practice specializes, like I focus on nursing home negligence litigation. So I sue nursing homes across the board. I have a mass tort against Rivera, a mass tort against Extendicare, and one against Sienna. You know, we've all been hearing lots about Rivera as it's connected to the federal pension fund for some of the federal unions. Sorry, I lost my train of thought. Absolutely, there's precedents. There's not a lot of litigation out there. It's very costly. And one thing that we don't really talk about that I think is really important is what these lawsuits are worth. You see in the news, $17 million class action, $25 million class action, $100 million lawsuit. These cases are not, that's just the window dressing. That's not what these cases are worth. We are not in the United States. In Canada, we don't have wrongful death damages the way you hear about in the States. So what we have primarily, especially with respect to the COVID deaths, and in particular under the Alberta Fatal Accidents Act, you have an allocation of a set amount of money. So for an adult child, 40 grand. That's somewhere around, I think that's what it is under the Fatal Accidents Act. You have to prove that your loved one passed away as a result of negligence, well now gross negligence, in order to recover that money. And it's the family members that are recovering for that loss of companionship or the loss of their loved one. And in Alberta, it's a set amount. In Ontario, it's not a set amount, but it's pretty similar. These are not large amounts of money. Litigation costs large amounts of money. So it's been very difficult for people from an access to justice standpoint to even bring these lawsuits in the first place. If someone contracted COVID and lived, I think you'd be lucky to get $10,000 of damages, unless you could prove other things like, you know, dehydration and, you know, there's long-standing effects. But if all you're talking about is getting COVID for a few weeks and you recovered, I think your damages are under $10,000 for pain and suffering, because our Supreme Court of Canada set the bar in the 1970s that the most amount of money that anyone can ever get for an award for pain and suffering is $100,000. And because you can't put a value on pain and suffering, it shouldn't be a high value. And in today's dollars with inflation, that amount is around $375,000. So imagine, this is across Canada, the most injured person imaginable. The max they can get for pain and suffering is $375,000. So you can imagine that everything else is on a sliding scale. And the argument that I hear constantly from the defense lawyers that are defending these cases on behalf of the insurance companies for these homes is, well, Melissa, they were old anyway. They were already sick. What really is the pain and suffering here? So that's what we're up against. So, you know, most of these cases end up settling because they're not worth these hundreds of thousands, let alone millions of dollars that you think these cases should be worth because of how egregious some of these violations are. It doesn't matter how negligent someone was. What matters is how the damage that's associated with that negligence is valued in our courts and in our law. And it's not very high. So, you know, that's something that I would personally like to see change down the road. For example, in the US, there is legislation that speaks specifically to damages as a result of nursing home negligence. I would like that kind of legislation to exist in Canada. That's my life-term goal.
A good goal. I have a question from Tara, who's a great advocate for neurodiverse Albertans, and she wants to know how this type of legislation or situation that we're seeing here playing out with this legislation will affect disabled people on supports.
You mean, I think
a question of people that actually live in facilities as well, because there's quite a few.
Right. I mean, look, we're talking about seniors and the elderly because that's who's predominantly, you know, a resident in these homes. And look, COVID isn't going away, right? We've heard this from epidemiologists. We're going to need booster shots, things like that. I doubt we'll see the level of outbreak that we saw initially in the pandemic. But what's problematic is that, yes, people who are longtime residents, residents with disabilities, of course, they fall under this too. They're residents of a home. They can't bring a claim. If the home is negligent, they have to prove it's grossly negligent. And now that's only with respect to cases to do with COVID, right? If I have cases where people have died from dehydration during COVID, but not because of COVID, that does not fall under this legislation, I would argue. I suppose there's an argument that it could be related or there still could be protection. Highly, highly unlikely. So we're really only talking about people contracting COVID, getting ill, and or dying from COVID in these cases. So yes, it's still a concern. and very problematic because they're just as vulnerable. Absolutely.
Perfect. Okay, we have time. We have actually 2 more questions. Do frail seniors who are dependent, like children, not have a special consideration in terms of legal protection?
Yes, under the criminal code. So this is another, we heard from Justin Trudeau in the fall during his throne speech that he was wanting to make changes to the criminal code. I actually testified at the House of Commons last month, I think it was, or in April, somewhere around there. A committee was struck to look at, what, among other things, whether changes should be made to the criminal code. Currently under the criminal code, you can be charged with failing to provide the necessaries of life, and criminal negligence causing death. Okay. We've never seen those provisions used against an owner, operator, or administrator. We generally see, what's crazy is when I speak to families and they say to me, I met, the home said that my mom had to be transferred to the hospital. I met her at the hospital and the doctors are like, are you taking care of her at home? Because you could be charged with criminal neglect. And my client would say, no, like they're at a long-term care home, no charges laid. We only see these kind of criminal charges laid against individuals caring for their loved one in their own home. We don't ever see this other than maybe you heard about the Elizabeth Wettlaufer case where there was a nurse who was actually murdering residents with insulin injections. Otherwise, we don't really hear about it in the context of a continuing care or long-term care home. That's something that I think we need to change, and we can make it more explicit that the administrators, owners and operators could be criminally responsible for failing to provide the necessaries of life and neglect and abuse. So we have the mechanism there. It's not exercised. And I think that change, my submissions to the House of Commons were that we need to have mechanisms in place that empower our law enforcement to be very sure about the fact that they can lay these charges. Let's make it explicit. Let's not have any ambiguity, right? Because exactly, we are talking about frail, elderly, vulnerable people. I found out this morning that the home that my grandmother is in is the subject of a director's order, which is is second only to revoking a license. I was terrified to read that. For 3 years of non-compliance of orders. God help any of the residents in that home that are the subject of the complaints. Rest assured, I'll be racing up to see my grandmother on Sunday to see what's going on. We need to have that accountability, and it needs to be in all places. It needs to be at the regulatory level. It needs to be at the level of the ministry and policy making. It needs to be at the level of enforcement with inspections, our criminal law and our civil law systems all across the board. There shouldn't be a gap in accountability, and there's gaps in every one of those areas currently.
Perfect. Thank you, Melissa. This, our last question is actually a little bit more complicated in that as we speak, or hopefully not as we speak, but they're also debating a bill called Bill 58, which is the freedom to care. And it's one that allows, by changes of regulations, not-for-profits to be exempted from quite a few regulations that are currently in place now. And, for example, we have a 3 minimum hour of care. If you're employed in home care, for example, and you have to go to work, basically what they're doing is changing those 3 hours to 2 hours where the employer can pay you minimum wages for those 2 hours rather than having to pay you for the 3. So this actual freedom to care bill should be better named freedom to exploit workers and undermine the services that some of these not-for-profits provide. So the question is, how might Bill 58, undermining the requirements of regulations for long-term care, intersect with this new standard for gross negligence, i.e. if 24-hour RN care is no longer regulated, lack of an RN on site cannot be cited in a future lawsuit. This government is just too much.
Wow. I mean, our government did similar things all throughout the pandemic, changing the regulations right, left, and center, removing requirements to chart things, and like you name it. It's a little difficult for me to answer that because I'm not sure about some of the Alberta provincial legislation. I can tell you that Bill 70 applies to lawsuits against government, okay? Which means if you have a standing lawsuit against the government for that, if, like, let's say you were to allege that the negligence or gross negligence was that piece of legislation. But most, I assume that Alberta has a similar piece of legislation what we have in Ontario. We have something called the Crown Liability Proceedings Act, and every government has a piece of legislation like this. It limits the actions, the lawsuits that you can have against the Crown or the government. Generally speaking, across the board, you can't sue a government for policy decision, which is legislation, regulation, policy, right? You can sue for the operation of that policy. So you can't sue a government for enacting a piece of legislation you don't like, but you can sue them if they negligently carried out that the obligations outlined under that legislation or regulations. And the reason for that, there is policy reasons, and that's founded in our very basic tenets of our law, namely that you don't want to have, appointed judges that are not elected overriding elected officials' agendas, because you can elect a new government down the road and repeal the legislation or change it or amend it, what have you. That's why, policy decisions are generally can't come under fire. And so the debate becomes between what's a policy decision, what's an operation decision. I don't know what Alberta's legislation is in that regard. I can tell you in Ontario, Ford, again, true to form, in an omnibus bill that passed at the beginning of his reign, I will say, he tried to even limit lawsuits against the government for those operational decisions. And we had our Court of Appeal recently ruled on it about a month ago and said, no, that's not the case. You can still sue for operational decisions. So, but that took 2 years of litigating all the way to the Court of Appeal, with any action that was against the government stayed in the meantime. This is the impact of having rushed legislation like that. So I don't know if I completely answered the question, probably not, because I'm not 100% familiar with the Alberta laws, but those are the basic sort of principles.
Thank you so much, Melissa. I'm just going to end the question period with a comment that came in, and it's basically kind of describes everything that we talk about. It is big business supporting big business, and once again, the people who pay the price, some with their life, are the little guys, you and me. So very true. I really want to thank you for sharing your expertise with us today, Melissa. The reason why I had said that this is a very timely discussion is because this morning, Friends of Medicare and Public Interest Alberta, along with 24 other organizations, both labor, civil society, and seniors groups, sent an open letter to the Minister of Health, Jason Kenney, our Premier, as well as the sponsor of Bill 70, voicing our concerns and our opposition to Bill 70. It was signed by 24 organizations that in total represent hundreds of thousands of Albertans. And we wanted to make sure that they knew that the voices represented there were people that had huge concerns with how it is that they're going to vote this afternoon on this bill. That's part of a campaign that we currently have on. So if you would like to add your voice in opposition to this bill, you can definitely go into Friends of Medicare website and add your name to this open letter. It will be tabled today with the 24 organizations by MLA Christina Gray from Edmonton Millwoods. And like I said, we hope that more people learn about this bill and the impact that it will have. As Melissa says, this is not ending now. We will be engaging in an ongoing campaign in preparation for, like I said, the legislation that will be coming down in the fall session. And if we need to do as much as we can to repeal this bill, and if that means working towards a change of government, and that's where our end goal needs to be. Read about the open letter. Alyssa just posted the website. Please sign on to it. Sign on to our mail list. You don't have to become a member. Nice that you do, but if you don't want to, you can also just get our information. And I would like to thank everybody for staying with us past 12 o'clock. And again, a huge thanks to you, Melissa, for sharing your expertise with us. Thank you so much.
My pleasure. Thanks for having me, Sandra and Alyssa.
Thank you, everyone.